Students, in our last class, we have studied about the sources of law, and in that we have discussed about first legal source, that is the custom. Now we are going to start with the second, that is the legislation. Now we will discuss the literal meaning. The term legislation is derived from the Latin words legis, which means law, and latum, that is to make or to set. Therefore, legislation is making of law. It also refers to the laws made by the legislature. If we talk in broader way, it includes all the sources of law, any act done with effect of adding to or altering the law. It is the source of law which consists in the declaration of legal rules by a competent authority. There are two reasons for taking the legislation as a source of law. First, it involves the laying down of legal rules by the legislature which the state recognizes as law. It has the force and the authority of the state also. The meaning of legislation is given on page number 40 of your book. And what is there? Jurists have expressed divergent views about legislation as a source of law. According to Bentham, legislation includes both the process of lawmaking and the law evolved as a result of this process. Austin says legislation includes activities which result into lawmaking or amending, transforming, or inserting new provisions in the existing law. But if we strictly say legislation means enacted law or statute law passed by the supreme or subordinate legislature. The definition given by Salmond: it is the declaration of legal rules by a competent authority, and it includes all methods of lawmaking. It includes every expression of the will of the legislature. Gray, in his words, says formal utterances of the legislative organs of the society. There can be no law without legislative act. Now, legislation is divided into two major categories, that is supreme and subordinate legislation. Subordinate legislation is also called as the delegated legislation. Here in your book, page number 40, what is there? Legislation may be supreme or subordinate. Legislation is supreme when it proceeds from the sovereign power in the state and is incapable of being repealed, annulled, or controlled by any legislative authority. In India, we see the parliament is sovereign but not supreme, although it possesses the power of supreme legislation. Supreme legislation is the primary legislation. It means it is made by sovereign or legislature body. It cannot be repealed, controlled by any other body rather than legislature itself. Subordinate legislation is a legislation made by any authority subordinate to the legislature. According to Sir John Salmond, subordinate legislation is that which proceeds from any authority other than the sovereign power and is therefore dependent for its continued existence and validity on some superior or supreme authority. Most of the enactments provide for the powers for making rules, regulations, bylaws, or other statutory instruments which are exercised by the specified subordinate authorities. Such legislation is to be made within the framework of the powers so delegated by the legislature and is therefore known as delegated or subordinate legislation. We can also say that subordinate legislation is that which proceeds from any authority other than the sovereign power. Earlier, the law made by British colonies and British colonial administration and parliament, superior court judges, universities, companies, all these come under the subordinate legislation. Now the various forms of subordinate legislations are colonial legislation, executive legislation, judicial legislation, municipal legislation, autonomous legislation. We can see on page number 41. Colonial legislation is the British colonies and other dependencies were conferred lesser power of legislation and are subject to imperial legislature. The laws so made by colonial governments could be repealed, altered or suspended or superseded by the imperial legislature, namely British Parliament. Next is the executive legislature. The Parliament frequently delegates its rule-making power to certain departments of the executive organ of the government. Such rules have the force of law. Now, the Parliament has delegated or has given the rule-making power to certain departments of the executive organ, which are able to make law or which have given the instructions which are equivalent to law. Judicial legislation, in certain cases the legislative powers of the rule making is delegated to the judiciary and the superior courts are authorized to make rules for regulation of their own procedure in exercise of this power. This is judicial legislation. Now the municipal legislation, the municipal authorities within their territories to make bylaws or for limited purpose such as water tax, land urban cess, etc. Next is autonomous legislation. The state sometimes allow private entities or the bodies such as universities, companies, corporations, etc. to make bylaws for regulating the conduct of their business. Now, this delegated legislation is being controlled by threefold controls, that is the procedural controls. This include prior consultation of interests which are likely to be affected by the proposed delegated legislation, prior publicity of proposed rules and regulations, publication of delegated legislation being made mandatory. Next is the parliamentary control. This method of controlling delegated legislation is to lay it before the parliament so that members get an opportunity to discuss and at times amend it. And third is the judicial control, in which the judiciary exercises effective control on delegated legislation. Whenever a law made by the executive is found to be inconsistent with the constitution or ultraviolates the parent act from which the law making power has been derived, it is declared null and void by the court. We can discuss three cases here. Chintaman Rao versus State of Madhya Pradesh, in which the Central Province's Regulation of Manufacture of BDs Act 1948 permitting imposition of a total prohibition upon those carrying on business of manufacture of BDs during agriculture session was held to be violative of Article 19(1)(g) of the Constitution because it interfered with the private business, hence notification under the Act was void. Next we can take example of Deepak Sibal versus Punjab University. In this, the Supreme Court held that the Punjab University rules for admission to the evening LLB classes were the discriminatory and violative of Article 14 because they restricted admission only to the employees of the government, semi-government and similar institutions and excluded the employees of private sectors and meritorious students. Next we are having Menka Gandhi versus Union of India. It can be concluded that any administrative rule making can be challenged on the ground of unreasonableness within the purview of Article 14. In your book on page number 42 and 43, there is the legislation process topic. In that there is process of formation of an act by introducing bill in the Rajya Sabha or Lok Sabha, and money bill is also discussed. We can discuss in short how the process of formation of act from a bill takes place. In case of ordinary bill, if it is introduced in either Lok Sabha or Rajya Sabha, then it is discussed in Parliament. Then if needed, the bill is recommended to a select committee or joint committee. Then it is set to voting. For ordinary bill, 50% of the members are to be present and required for voting. For amendment of bill, not less than 2/3 members to be required for voting. After counting of votes, if there is tie, that is 50-50% or 60-40% voting, then presiding officer of the house casts its vote. Then bill is presented to the president, who signs the bill or gives its assent, and in this way the bill become an act. In case of money bill, any bill which contains provisions for imposition and abolition of taxes, for appropriation of monies out of the consolidated fund of India, are certified to be money bill. Now, how this money bill is passed? It can only be introduced in Lok Sabha with prior recommendation of the president. Here the president, first it goes to the president. Then it is passed by simple majority in Lok Sabha and then sent to Rajya Sabha. Rajya Sabha can only give recommendation to the bill which Lok Sabha can accept or reject. Rajya Sabha cannot hold the bill for more than 14 days, and then the president, it is again sent to the president, who has to pass the bill and cannot send it back to the parliament for amendment. So in this way the money bill is passed. Then we come to the merits. It is only a source of law but also most effective instrument for legal reform. Legislation satisfies the requirement of natural justice that laws shall be known before they are enforced. Law is declared in the form of legislation and same is enforced by the court. It makes rules for cases that have not yet risen, and the demerits of legislation are: certain legislation abridge the rights of individuals and are referred to judicial review. It results in amendment to the constitution which sometimes lead to conflict between legislation and judiciary. Now, in this way we have completed this topic of legislation as the source of law. We are going to discuss precedent in our next topic. This should be discussed as the second source. Next we will take the judicial precedent.